So this is the Plunger Rebellion.
This is it.
Post office workers are having to make extra trips to empty the exterior because of the volume of last-minute filers to pay the income tax. William Wagener, for on second thought, this is what it looks like in Santa Maria, California on a cold, blustery day in April where the last-minute filers are lining up and the traffic is jammed. Meanwhile, down at there are at least 1,000 people gathering to protest here in Santa Maria. This is the biggest turnout I've ever seen for a political event in Santa Maria, California since Ross Perot ran for president in '92.
Exist without private property? Can America exist without the freedom of speech? Freedom of religion?
Well, good evening, everyone. I'm Cassandra, and I'm going to be your co-host for tonight. And it is On Second Thought with the good guy in the white hat next to me, William Wagener.
Thank you. Thank you very much, Cassandra. I must be William Wagener because I got the white hat. The other gentleman here in the studio is Uncle Sam. He's got the red, white, and blue hat. How you feeling tonight, Uncle Sam?
Down a little.
Down a little. Tea parties. That was the opening with the Tea Party, the Plunger Tea Party. The Tea Parties, in my opinion, are being co-opted by one political party to run mainstream, do nothing, continue the same bad policies, Republicans. That's just my opinion. And hey, I'm a Ron Paul registered Republican. But I just, I tell it like it is. Tonight, we got some interesting footage. We got part of the debate, the second debate between the candidates for Santa Barbara District Attorney. Now, don't change the channel. You think you're going to be bored to death. I'm telling you, you won't be bored. Stick with me. This is a really important office. If the DA won't prosecute you and the sheriff won't arrest you, most of your civil liberties are intact, even though on a federal level, they're trying to destroy our country, destroy your civil liberties. Tonight I have a shocking report from the U.S. War College former director, Alan Sabrowski. You've never heard this name before, and I'm not surprised. Like most of you never heard of Major General Albert Stubblebine, who says, and we have it in video, we've played it before, he says, it's on my YouTube channel at William Wagener, he says, ladies and gentlemen, the planes did not bring down the Twin Towers, despite all the media crap you've been fed for almost 9 years. The planes that hit the Twin Towers did not bring them down. Okay? And beyond that, we have the former U.S. War College director saying that, believe it or not, Al-Qaeda did not do the operation. The media's lied to you for a long time. So we're going to have that clip, and you're going to be shocked to find out who really did the 9/11 on September 11th, 2001. But hey, this guy was only director for 5 years of the U.S. War College. Gee, why should you listen to him, right? Because maybe he's a better expert than most people you've likely to come into. That's why you should listen to him. But this DA's race, I think, is really important. I want to go to a clip. Now, it's an edited clip. I haven't taken out any of the words. This is from the Santa Barbara debate for Santa Barbara District Attorney between Joyce Dudley, who just canceled today as I talked to her. She said, "Oh, Mr. Wagener, it's gotten so complicated. I'm not going to be able to be on your show on May 7th. And guess what? Josh Lynn, the other candidate, was supposed to be here tonight. I was going to give them both equal time, but not on the same night. He canceled tonight because he went to the funeral, which was many hours ago over at the golf course, for Christine Stanley. Now we sit here with neither one of the candidates, but we have this footage, and I think you ought to pay very close attention because just today, hours ago, I got some documents that are going to have impact to you when we read them to you live on television here on Friday night. the 30th of April. Because one of these candidates for DA claims to hold the high moral ground in ethics. But reading these court documents with the official stamps, it would appear to me one of these candidates maybe doesn't hold the high ethical ground. And we'll be getting to that tonight. So let's go to this tape, and I'll be back with Cassandra and Uncle Sam, who I hope will be feeling better. He probably won't when he hears this stuff. But we'll go to that video of the debate in Santa Barbara a couple weeks ago between the district attorneys. Listen carefully, especially the last minute. It's only 3 or 4 minutes. Here we go.
The acting district attorney, I've done the job. It is a very complex job. It's a very rewarding job, but it's also one that you can't simply jump into. You have to understand in the district attorney's office, budget, the folks that work there, where can we best serve the community, how can we best serve public safety. The reason that Tom Sneddon and Christy Stanley and virtually every administrator who's run the office for 28 years supports me is because they understand I'm the best candidate for the job, for that job, as the administrator of the district attorney's office, not some other organization. And I'm proud to have those endorsements, and I'm proud to say that's why I'm the most qualified.
Ms. Dudley, rebuttal.
Thank you. I understand how the district attorney's office works. I was already prosecuting serious felony charges before Mr. Lynn was even sworn in as an attorney. I also understand it because I was president of the District Attorneys Union for 2 years. I did the negotiations along with 2 other people for 2 years. I've worked with everybody in that office for almost 2 decades. I understand how that office works, and I understand that at times we have let you down, and there's going to be a change. I will treat this office the way it should be treated. That is, I will be a public servant, and I will serve you. Thank you.
The second question, to which Mr. Lynn will respond first. What type of training would you provide others in your office concerning ethical issues and standards?
Well, the first way that we learn as prosecutors is on the job. That's the best way to learn. We certainly have in the past and for many, many years sent our prosecutors to school, what was often known as baby prosecutor school, the California DA's Association. That's a great program, but the best way to understand these things is to do it on the job. I have taken, in my role as chief trial deputy, junior attorneys and assign them to higher cases, to doing things called lifer hearings at prisons, to felonies, to work them second chair in murder cases, to allow them to understand as they progress as attorneys and as they get into the more serious business of prosecution, how to go to court and do the right thing each and every time. I have never been called on the carpet for any ethical violation whatsoever in my career, and I'm proud to say that the reason for that is because I've behaved in a way that's consistent with the rules, that's consistent with what's expected and what's befitting of this high office. And the way that we train our younger, our newer deputies, and the way we insist that the veterans behave the way that the community expects law enforcement to behave is by example. And I will lead by example, as I have previously, that ethics and integrity will start from the top down when I'm the district attorney. Thank you.
Ms. Dudley.
Thank you. Ethics is critical. I think ethics is so important that when asked to teach at the Santa Barbara College of Law, I couldn't do it for a while with my young children and my job at the district attorney's office, but when I was offered the job to be the professor who taught professional responsibility and ethics at the Santa Barbara College of Law, I embraced the decision to become a law school professor. Lawyers must behave ethically at all times. All we have as attorneys is our reputation, and we always have to do the right thing because you trust us. Especially prosecutors. We're the gatekeepers to the criminal justice system, so it's critical that we ensure that our criminal justice system remain just. Josh just mentioned the California District Attorneys Association. I've been a teacher, and I was a subject matter expert in terms of sexual assault crimes, arson crimes for the California District Attorney's Office for the last 15 years. When you're preparing yourself to be a professor, whether it's at the law school or throughout the state for the California District Attorneys Association, you want to make sure that prosecutors, not just here but everywhere, behave ethically and fight hard for, of course, public safety. Thank you.
Mr. Lynn, rebuttal.
discuss ethics in a vacuum, as it were. Ethics are applied to cases, they're applied to the daily lives that we lead as prosecutors, and how do we steward families through the court process that is so difficult at times. We meet families at usually a point in their life that is really as bad as any other point that they've come across, and our ability to try to help them get through the system in a fair and ethical manner, not a win-at-all-costs manner, just a fair and ethical manner, is paramount to what we do. It is the fact that I'm the only one sitting here who has never had those issues with respect to judges in our courtrooms, and I'm very proud of that fact. That is how one leads by example.
Well, I don't think Uncle Sam could hear that, could you, Uncle Sam?
No, I couldn't.
Couldn't. That was a debate about ethics between the two. There's only two, Cassandra, candidates running for district attorney. One is a gal, she's been in there a long time. Her name is Joyce Dudley. She's been in a lot of county jobs. I don't know how she got into the DA's race or why, but she's there. And the only opposition is a young guy named Josh Lynn. Now, some of you will remember my show last week. We showed a man who didn't want to be found, but we found him. And he declared on his Form 700, one page on his, that's all. He didn't have a house. He didn't have stocks and bonds. He didn't have any holdings to declare on his Form 700, yet we found him living in $1 million plus home. And it appears he's got several properties. And he's the guy that gave Josh Lynn $80,000 loan. Is something wrong with that? How many people of you out there watching would give $80,000, yet you supposedly have no home in your name, you have no stocks and bonds, you just retired from the DA's office this month, April 1st. So I got to ask him some questions, but he doesn't appear to want to come on television and answer any questions. So just today, just hours ago, down at the Santa Maria Airport in California, a certain person came and gave us a file. How thick is that, Cassandra? Half inch? Inch?
I'd say about half an inch.
Half-inch file on court documents of what Miss Dudley did wrong. I'm receiving this file. It's the same file. We've added nothing. We've taken nothing out of it. And these are public documents, but most people will never go research it. This gentleman was good enough to bring me these documents. And I'm going to read just one of them. It's the case of the people of State of California versus Rodolfo Carlos. And it's in Superior Court, County of Santa Barbara, the appellate level. Okay, this is the appellate level. And if you want to look it up, this was filed in 1993. It's case number 1946-11. And it's the decision on appeal. And this is what the court said. Defendant appealed from judgment entered upon a jury verdict in Santa Barbara Municipal Court, convicting him of misdemeanor violation of Penal Code Section 273.5, subsection A, battery with infliction of corporal injury upon a cohabitant. Appellate makes three claims of error. That when the prosecutor asked an expert witness a hypothetical question, closely tracking the facts of the case, it called upon an opinion on the ultimate issue in violation of the restrictions imposed by the Evidence Code, Section 1107, subsection A. 2, that the calling of the expert witness in the case in chief, rather than the rebuttal, was prejudicial error. 3, that the prosecutor committed prejudicial misconduct in final argument by a statement before the jury to the effect that the defendant had failed to meet the burden of raising a reasonable doubt about his guilt. We reverse the conviction and remand for a new trial or other appropriate proceedings based on the violation of the Evidence Code, Section 1107, through the testimony, the expert witness. For the guidance of the court and the parties in further proceedings, we also briefly discussed the appellant's remaining contentions. The victim, Heather Berry, a young woman, age 19, pregnant by defendant, etc., 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 etc. But guess who people, who was the prosecutor on this case? And they bring up the battered women's syndrome and all this kind of stuff. The prosecutor stated to the jury that the defendant's testimony denying the charges was enough to raise a reasonable doubt. The prosecutor argued the expert's opinion showed that the victim had been telling the truth in her initial statements. Now, the question is not whether the defendant was really guilty, even though it's overturned. The real issue that comes up here, and he says the victim's nor defendant's testimony in court was worthy of belief. After brief deliberations, the jury returned a jury verdict. Hypothetical question to people's expert on battered women's syndrome. Now, who do you think was the prosecutor on this? Could it have been Josh Lynn? Was he even in the DA's office in 1993? Or was it Miss Dudley? I'm waiting to hear you guys. I can't hear you on the other side of the television set. You got to yell a little louder. It's an interesting case because in the end, concurring opinion by Judge Dodd, I agree with the majority opinion concerning the prejudicial effects of the improper expert testimony and consequently the necessity to reverse the judgment. I write separately only to note that I am not convinced that the order of proof employed here was within the discretion of the court. I am of the opinion that it may have been error to permit the people to introduce evidence in support of the credibility of the victim's pretrial statements at a time when the defense had not yet put on evidence. And therefore, when the evidence relating to her credibility was technically irrelevant evidence does not become proper because it anticipates a defense which likely will be, but has not yet been put forth. However, the resolution of this issue can wait for a day when it's essential for the judgment. I reserve decision as to whether this error would require reversal here in the absence of points discussed by the majority. I concur in the judgment and in the other portions of the majority opinion. That was Bruce William Dodd's judge. Now, what the other opinions had to be is pretty long, and I know this would